instance of kidnapping is so unspeakable that they can do it. You try administering a system like that. So I'd say where we are up to now is the death penalty is confined to murder. That's where we are. And as a practical matter, that's where it's been. And Justice Kennedy explains all this pretty well in his opinion. I'm giving you a notion why, when you read that, I think that the constitutional issue before us is different. Of course they're different from one provision and another. And you may or may not agree with my reasoning or how I came out or whatever it is, but those are reasons that I think make that different. And you have to say no at some point. Now, abortion, we have a long history. And I said when I was confirmed that I was not going to the court with a mission on that issue. And I've taken that as precedent, and I've followed it. That's what I feel I'm doing. I feel I'm following that precedent. And it's more complicated, but there we are. So, you see what I've tried to do in explaining it even now, give you a rough hint of why I think the issues in those cases, from a constitutional perspective, are different. Though, of course, if you look across the vast majority of cases, I do think the Constitution gives a great deal of leeway to legislatures. It's supposed to, and we should interpret it that way. But Holmes was famous for saying, soon you come to, in a case, and you don't have to sit there too long, before you find what he called a can't help. And a can't help for a judge is not something just a personal moral belief. It's you just can't help this because that's what it does mean. All right? So nobody thinks a view of judicial restraint means everything is constitutional. And as long as we're human, which I hope judges are, as long as that's so, there will be instances where they think, from a legal perspective, this is it. This is where we draw this line. There we are. And then you write opinions which try to explain that as best you can. Or you join one because you don't want to write in every case. And even if it isn't, from your point of view, the perfect thing, it's close enough. And maybe from somebody else's it's the perfect thing. Okay? So there we are. So I'm just explaining to you, not justifying. I'm just explaining why I don't think I'm being inconsistent. And you ask my 8 other colleagues the same question, and they believe they are consistent. And they will, if they need to, give you the answer, which will mostly be some form of the words, read 92 opinions and then you'll understand.
Justice Breyer, ours is a system of governmental checks and balances. What's the check on the power of the Supreme Court?
Oh, what a good question. Well, Learned Hand used to say when people asked him the question about judges, and he'd always point to the law books, and he said, there it is. Those books. There it is. And he knew that wasn't totally satisfactory because when people ask that question, they really want to know, well, what about the cases the law book doesn't give you a cut and dried answer to? And that's where the bite is of this. And the answer, I think, is, I don't know the full answer, but I do know 2 parts, and they're contradictory. And one part is we're there to decide these cases as best we can without finger in the wind. That's the job. And you feel it. So anybody who starts reading opinion polls and looking to the polling box or whatever is going to be in trouble. And we're lucky enough in our federal system. A lot of judges aren't. But we're lucky enough to have a guarantee so we're not even tempted. And that's what we're there for. At the same time, although you don't decide a case with an eye towards public opinion, unless the public believes in this institution, which is an institution of independent judges, as an ideal, unless they believe in it, unless that notion is popular, it won't survive. Because we do live in a world where the power is in the hands of the people. And that's just it. So you've got to have an institution that has public support. And at the same time, you have to decide the cases independently. Now, where does that lead us? Well, you tell me. You tell me. And how we maintain that, that's a good question, how we maintain that. And it's filled with problems, and that's another hour and a half, which I'll spare you. But there we are. Now you say, well, what's the full answer? I don't know. I'm thinking about it. If you that's like Jack Benny. You remember that famous thing? They'd say your money or your life, and Jack Benny would say, what's your answer? Money or life? No answer. I'm thinking. But I'm going to try to write something about it. Now, that won't be very definitive, but it's a good question that has no definite answer. But I'll tell you the check's in here on these tough things where it's unpopular, and it's meant to be. But the reward is also in here.
Justice Breyer, I want to ask you about the court and unanimity. One of the last times we had a conversation like this among a few intimate friends on C-SPAN, we had a new Chief Justice who came in promising to promote unanimity. But he didn't do so well. At the end of that term, it was 2 terms ago, 33% of the cases were decided by 5-4 splits.
I was not a happy camp.
No, I asked you, what should the Chief Justice do? And you said, well, he should join my opinions.
I hope I didn't say something quite.
You did. But things look different now. So last term, only 17% of the cases were 5-4, among the highest unanimity rates in recent years. Does the Chief Justice get some credit for this? Is this a new era of a bipartisan love fest on the Supreme Court? Or is it too early to tell?
I don't think he got blamed for the year before.
Some blamed him.
Well, I didn't blame him. I mean, you don't get blame and you don't get credit.
So what explains it?
It's the 9 independent thinkers, and I'll tell you, independents among the 9, people try to get together. They try, and no human being can bring everybody together, and no human being can drive everybody apart. We're there, and we're in the conference, and we talk to each other, and we get along well personally. There's no problem. There have been periods in the court's history where people haven't gotten along well personally. We get on well personally, all of us. And we're trying. And sometimes we're more successful, and sometimes less. And I deliberately use the word we, because it's a question of a group. And it's quite a group. I mean, that job requires and promotes and values independent thought. At the same time, there's a virtue in and a necessity for cooperation. Very complex institution. And that is, well, while I enjoyed the panel today very much of the news people, and I thought it was a very good panel, I particularly, the one remark that's on this question that really stood out in my mind was Dahlia Lithwig's. And she said, we won't know for 20 years. And that's true. Because the Chief Justice doesn't know. Justice Alito doesn't know. I don't know. No one knows. What ultimately will be the cohesive quality or non-cohesive quality of this group. It's a function of what you're trying to decide. It's a function of how that fits in. If I were to have a division there, my division would not necessarily lie between conservatives and liberals in a political sense. I think people do have quite different approaches. And remember the 6 factors I mentioned, they value different parts. Justice Scalia values highly history, tradition, the precedent, and the text. And he's very suspicious of purpose and consequence. I value highly purposes, values, consequences. But I'll certainly think the others are relevant. Of course they're relevant. But there are differences of outlook among judges. And when you're talking about a court, that's more likely to reflect fault lines, I think, than all these things. I'm not in the generalizing business, you are, and so are you. But I think that those kinds of things are really probably more important.
Justice, there's been a lot of controversy lately about the citation of international law in Supreme Court opinions. In your judgment, what should the role of international law in the decisions of courts around the world be?
Important. Now, why? I think there's a question